Slave Traffic, Chapter 2. Sell, purchase, barter, mortgage, auction, coffle gain, shipments, as absolutely as in the case of any other property, and by the same tenure. This feature must result, of necessity, from the legal relation of ownership exhibited in the first chapter. The quotations there made cover explicitly this ground. The master may sell him. Slaves shall be sold, transferred, or pawned as goods, or personal estate. For goods they were, and as such they were esteemed. Any modification of this feature must evidently relax the application of the principle of ownership and limit its operation. In the Spanish, Portuguese, and French colonies, such modifications, nevertheless, obtained. The Code Noir, Art 47, prohibits the selling of the husband without the wife, the parents without the children, or vice versa. In cases of voluntary sales, made contrary to this regulation, the wife or husband, the children or parents, though expressly retained by the seller, pass, by the same conveyance, to the purchaser, and may be claimed by him without any additional price. See Stevens' Slavery, 69. Stroud's Sketch, 51. Footnote. This remarkable provision arises, doubtless, from the fact that the laws respecting slavery in those colonies are framed in the mother country, and not, as in the British colonies, by colonial legislatures composed of slaveholders. What bearing this humane regulation would have upon our internal slave trade, if it were established in this country, the reader will see by the following account of its operation. Says the compiler of the Annals of the Sovereign Council of Martinique, this law has always been rigidly executed whenever a claim has been set up on the part of the purchaser. I have known slaves who have been sent to Guadalupe or St. Domingo to be expatriated and sold, to reclaim their children remaining in our colony, with success, through the action of the purchasers in the colonies to which they were sent. See Stevens' Slavery, 69 and 70. Citing Annals de la Martinique Tome I, page 285, Vide Stroud, page 51. It would not, probably, be quite as easy for slave children to recover their aged parents, or for husbands to reclaim their feeble and sickly wives by this action of the purchasers. Humanity, nevertheless, would gain much. The principle of human chattelhood would be weakened. Perhaps it was partly through the influence of this and similar relaxations of the principle that the entire system was swept away in Mexico and the South American republics. By this feature of the Code Noir, the bondage under its jurisdiction was made to resemble, in this aspect, the feudalism and serfdom of Northern Europe, where the villein is attached to the soil, rather than the chattel slavery of the American slave states. In Pennsylvania, in New York, perhaps in other American states, when measures were taken for the prospective abolition of slavery, the sale of slaves to be sent out of the state was prohibited by express statute. Except in these instances, we know of no departure, in the matter of sale and transfer, in our American slave states, from the principle of unrestricted and absolute human chattelhood, unless the anomaly be found in the state of Louisiana, as hinted in our first chapter, where it was stated that slaves are held in Louisiana as real estate. In the slaveholding states, says Judge Stroud, except in Louisiana, no law exists to prevent the violent separation of parents from their children, or even from each other. Stroud's Sketch, page 50. Again, after dwelling upon these cruelties of the domestic slave trade, as being peculiar to the Republican states of North America, the same writer adds in a note, page 52, from the generality of this remark, the state of Louisiana must be accepted. The slaves are declared to be real estate, to be ranked among immovable property. When, therefore, the owner of slaves is, as I presume is most commonly the case, possessed of land, the slave cannot be separated from it by process of law. Besides this humane regulation, there are several others which deserve to be signalized, namely, if, at a public sale of slaves, there happen to be some who are disabled through old age or otherwise, and who have children, such slaves shall not be sold but with his or her children, whom he or she may think proper to go with. 1 Martin's Digest, 612, Act of July 7, 1806, Stroud Sketch, page 52 through 53. How far these provisions are, at this late day, available for the benefit of the slaves of Louisiana, we have no means of knowing. Louisiana has been a purchasing rather than a slave exporting state. The striking contrast between these enactments and the known usages and scenes of other states mark their anomalous character as exceptions which prove and illustrate the general rule of unrestricted chattelhood in our slaveholding states. It is to be noticed that these refreshing anomalies are witnessed in only one of the slave states, a state coming within our jurisdiction from under that of France, and receiving its earlier features of polity under the laws of Spain. Louisiana slavery took its type from the Code Noir and from the usages growing up under what our citizens are pleased to denominate Spanish despotism and superstition. Anglo-Saxon civilization and religion, with all their Republican and Protestant boastings, have not yet reached the same point of progress, nor do we learn that in Florida, acquired from Spain, the mild features of Spanish slavery have survived the transfer. The reason may be that too many Northern citizens, the most merciless of all slaveholders, have planted themselves there. Be this as it may, it is certain that the legal relation of master and slave, as commonly understood, practiced, vindicated, and protected in these United States, differs widely in the feature now under consideration from that defined by the Code Noir. We may venture to affirm that the commonly received exposition, as it exists in theory and practice in the church and the state, has been truthfully set forth by one of our most prominent and popular statesmen, the late Henry Clay, in his speech in the United States Senate, February 7, 1839, in which he said, "The moment that incontestable fact is admitted, that the slaves are property, the law of movable property irresistibly attaches itself to them, and secures the right of carrying them from one state to another." Footnote. It may be said that there is an exception to this statement of Mr. Clay in the laws of some of the slave states, prohibiting the importation of slaves from other states. Also, in the restrictions recently imposed, on motion of Mr. Clay himself, upon the prosecution of the slave trade from the federal district, those state regulations were, for reasons of policy or supposed interest, to encourage slave breeding at home instead of receiving supplies from abroad. Whether consistent or inconsistent with the rights of property, they have their precedent in the prohibitions of importations of other kinds of property by different nations and states. But, under our federal Constitution, the power of regulating commerce between the several states is committed to Congress, not to the states. And hence, in Mississippi, notwithstanding their prohibitory enactment, the slave dealers in 1836 through 1837 brought into that state and sold slaves to the value of $90 million. It is true that when they undertook the collection of their debts, the purchasers pleaded the illegality of the sales. The state courts sustained them, and thus they obtained the greater part of the importation without payment. The restriction in the federal district prevents dealers from bringing in supplies from the states for sale and shipment abroad, but does not prevent purchases and sales among the citizens. This definition, which is acted upon every day, identifies the legal relation and the slave system with the domestic slave trade, and its constant and violent disruption of the most sacred and tender ties of consanguinity and affection. If the legal relation does not produce this effect in respect to each slave, it does, in each instance, uphold and sanction the principle of chattelhood upon which alone the traffic in slaves rests. It recognizes the rightfulness of the traffic by recognizing the rightfulness of slave ownership, which includes the right of purchase and sale. This is what Mr. Clay affirmed, and, thus far, he spoke truthfully. The moment the right of property in man is admitted, and here lies the core of the relation, that moment the right of purchase and sale is virtually conceded likewise. It was a triumph of human sympathy over legal congruity and logical consistency that enacted the Code Noir. The exposition of Mr. Clay reduces slaves to level with poultry and swine. It denies to them personality and the attributes of human beings. It does this not merely in theory, but on a point of the most pressing practical importance. It certifies us that the Chattel principle is neither a dead letter nor an unmeaning abstraction. It exhibits the practical statesmanship, not of Henry Clay only, but of all who admit the validity of the so-called legal relation. A similar exposition we have from Reverend James Smalley of the Amity Presbytery, Mississippi, in a pamphlet written in defense of slaveholding, alluding to the charges of abolitionists. He admits the facts adduced by them, but denies their criminality, and he says, "If slavery be a sin, and advertising and apprehending slaves with a view to restore them to their masters is a direct violation of the divine law, and if the buying, selling, and holding a slave for the sake of gain is a heinous sin and scandal, then verily 3/4 of all the Episcopalians, Methodists, Baptists, and Presbyterians in 11 states of this Union are of the devil. They hold, if they do not buy and sell slaves, and, with few exceptions, they hesitate not to apprehend and restore runaway slaves when in their power." It will be noticed that the holding, the buying, and the selling of a slave are here put together as being essentially of the same character, and common sense as well as the law of the peculiar relation, as expounded by Henry Clay, attests the same thing. A large portion of Willard's law of slavery is occupied with legal decisions connected, directly or indirectly, with cases growing out of the transfer of slaves. One division, or chapter of the work, treats of the increase of slaves, to whom the increase belongs, of the grant or device of the increase. Another topic is, of the title to slaves. Another, of warranty. Another, of hiring of slaves. Another, of mortgage of slaves. Another, of dower of slaves. Another, of the division of slaves. Another, of the remainder in slaves. Upwards of 150 pages of the book, nearly 1/3 of the entire work, are occupied with these topics. From the extent and variety of litigation coming before the courts and demanding these complicated legal rules and decisions, it would seem that a very large part of the business transactions of the people must consist in the reception or transfer, in some form, of this species of property, and, at every step, it appears that transfers of slave property are made upon the same principles that govern the transfer of other property, that it is held and conveyed under the same tenure, and with as little sense of the impropriety of the transaction, thus placing, in practice, a human being upon a level with a mere thing. Thus, when the judge, the lawyer, or the law compiler or author would lay down the legal rule by which the decision should be made in a litigated case, in a matter of sale, delivery, possession, warranty, etc., he looks up the precedents and rules originally occurring or laid down in respect to a mare or a colt, and then, with the utmost coolness and gravity, applies it as valid law to the sale, delivery, or warranty of a girl. An instance of this occurs in Wheeler's Law of Slavery, page 119, 120, in a note on the case of Smith versus Rousey, spring term 1821. A case in which the girl purchased was unable to travel home with her new master, 8 miles distant, and soon died. A lawsuit followed, and the law concerning other livestock determined the case. In one instance, we find a Negro woman named Peg sold for $300, with leave to return her in 3 weeks if the purchaser did not like her. With her new master, she became frostbitten, which rendered her of little value. Hence a suit between the parties, judgment given, an appeal taken, judgment reversed, just as in the case of a horse or an ox. On page 79, we learn that 5 years peaceable possession gives a title to a slave, and which, if lost, may be regained. We infer that if possession, as between contending claimants of slave property, be thus potent, it would be at least equally powerful as between the possessor and the slave's legal right to freedom. Of the extent of the slave traffic between the slave-growing and planting states, of which we shall speak presently, some tolerably reliable approximation towards the true statistics may be gathered. But of the extent of local and neighborhood transfers, with which Wooler's reported cases seem mostly occupied, very little can be accurately known. We can only say that a perusal of Wooler's Law of Slavery has very greatly swelled our own estimate of apprehension of that extent. It can hardly be supposed that more than a tithe of such transfers would occasion lawsuits, but we seem to see the courts crowded with them, and a compilation of the reported cases swelling a law volume. It must be folly to pretend that the slave traffic occupies only the vulgar portion of Southern society, when it figures so largely in the courts. Slaves may be sold and transferred from one to another, without any statutory restriction or limitation, as to the separation of parents and children, etc., except in Louisiana. Wooler's Law of Slavery, page 41. It can hardly be necessary to cite witnesses to prove that this feature of the slave code, which licenses the slave trade and the separation of families, is not a dead letter. But it might be useful to impress upon the reader some idea of the magnitude and the atrocity of this traffic. This would open a wide field. We might refer the inquirer to World Slavery as it is, to Jay's Inquiry, and to Goodall's History of Slavery and Anti-Slavery, for collections of facts and testimonies on this subject, upon which we cannot enlarge here. The extent of the slave trade in America may be conceived from the testimony of the Presbyterian Synod of Kentucky that these scenes, namely coffle gangs, are daily occurring in the midst of us, that there is not a neighborhood where these heart-rending scenes are not displayed, that there is not a village or road that does not behold the sad procession of manacled outcasts, whose chains and mournful countenances tell that they are exiled by force from all that their hearts hold dear. Its general prosecution may be seen by the numerous advertisements of both purchasers and vendors in the most respectable newspapers in the slave states, as, for example, the following: Negroes for sale. A Negro woman, 24 years of age, and her 2 children, one 8 and the other 3 years old. Said Negroes will be sold separately or together, as desired. The woman is a good seamstress. She will be sold low for cash, or exchanged for groceries. For terms, apply to Matthew Bliss and Company, 1 Front Levee, New Orleans B. I will give the highest cash price for likely Negroes, from 10 to 25 years of age. George Caffart, Alexandria, D.C. Gazette. 50 Negroes wanted immediately. The subscriber will give a good market price for 50 likely Negroes, from 10 to 30 years of age. Henry Davis, Petersburg, Virginia, Constellation. Having obtained their supplies and driven or shipped them south, the dealers offer them for sale in advertisements like the following, which appeared in the papers of Charleston, South Carolina. 120 Negroes for sale. The subscriber has just arrived from Petersburg, Virginia, with 120 likely young Negroes of both sexes and every description, which he offers for sale on the most reasonable terms. The lot now on hand consists of plowboys, several likely and well-qualified house servants of both sexes, several women with children, small girls suitable for nurses, and several small boys without their mothers. Planters and traders are earnestly requested to give the subscriber a call previously to making purchases elsewhere, as he is enabled to sell as cheaper than can be sold by any other person in the trade. Benjamin Davis, Hansburg, South Carolina, September 28, 1838. The respectability and profitableness of the traffic may be inferred from the fact that some of the largest shipping merchants are slave merchants, that they own and charter and freight numerous vessels to transport their slaves coastwise, and invest princely fortunes as capital in the business. The importance of this branch of commerce will be apparent from the speeches of leading statesmen and the paragraphs of prominent editors. Henry Clay, in his speech before the Colonization Society in 1829, said, "It is believed that nowhere in the farming portion of the United States would slave labor be generally employed if the proprietor were not tempted to raise slaves by the high price of the Southern market, which keeps it up in his own." Mr. Golson of Virginia, in the same speech in the state legislature before quoted, after claiming his Negro woman as his property, like his brood mares, expatiated upon the profitableness and the rightfulness of the investment. The owner of land had a reasonable right to its annual products, the owner of brood mares to their product, and the owner of female slaves to their increase. And I do not hesitate to say that in it consists much of our wealth. The editor of the Virginia Times, in 1836, made a calculation that 120,000 slaves went out of that state during the year, that 80,000 of them went with their owners who removed, leaving 40,000 who were sold at an average price of $600, amounting to 24 millions of dollars. Similar estimates and testimonies might be added. The annexation of Texas and the conquest of Mexico were openly advocated and notoriously prosecuted for the object of extending the area of slavery, and thereby opening a new slave market for the breeders of slaves. And the coastwise slave trade has been protected by the national government, and its diplomacy prostituted to this purpose. The particulars may be found in Jay's view of the action of the federal government in behalf of slavery, and Jay's review of the Mexican War, also, briefly, in Goodell's History of Slavery and Anti-Slavery. Of the character of this traffic little more need be said. By our own national government, the African slave trade is branded piracy. But Thomas Jefferson Randolph, in the Virginia legislature in 1832, declared the domestic slave trade to be much worse. About 1,100 citizens of the federal district, including Judge Cranch and the principal clergy of the district, petitioned Congress against it as there existing, and, comparing it with the African slave trade, they said that it is scarcely less disgraceful in its character, and even more demoralizing in its influence. This was in 1828. The grand jury of the district had, many years before, 1802, presented it as a nuisance. Footnote: by the Act of Congress of 1850, the slave dealers are prohibited from making the federal district a deposit for slaves, but this does not prevent any citizen of the district from selling his slave or purchasing a slave from abroad. Its character there, at that time, differs nothing from its character in the different states at present. The New Orleans Courier, February 15, 1839, says, "The United States law prohibiting the African slave trade may and probably does put millions into the pockets of the people living between the Roanoke and Mason and Dixon's line. Still, we think it would require some casuistry to show that the present slave trade from that quarter is a whit better than the one from Africa." It may be asked, who are they at the South that prosecute this domestic slave trade? The Presbyterian Synod of Kentucky, describing its extent, its common occurrence, and its barbarities, inform us, in the same paragraph, that professors of the religion of mercy, who hold to our communion, have torn the mother from the children, and sent them into returnless exile. Yet acts of discipline have rarely, never, followed such conduct. James G. Birney, long resident in Kentucky and a Presbyterian, says never followed such conduct. In the Presbyterian General Assembly of 1835, it was stated by an elder, Mr. Stewart of Illinois, and without contradiction, that even ministers of the gospel and doctors of divinity may engage in this unholy traffic, and yet sustain their high and holy calling. Elders, said he, ministers and doctors of divinity are, with both hands, engaged in the practice. Yet nothing was done or said by the assembly in condemnation of it. The testimony of Reverend James Smiley, already cited for another purpose, implicates 3/4 of 4 leading religious sects in the practice. If a distinction be set up between the Virginian breeders and Mississippi purchasers, gentlemen planters, on the one hand, and the human drovers, commonly called soul drivers, on the other, who ply between the two, disposing at the far south of their stock purchased at the north, we maintain that there is no legal or moral distinction between them. The legal relation is as innocent and as criminal in the one as in the other. The growers, the consumers, and dealers so necessary to them stand on the same level. Besides, the dealers are sometimes esteemed as respectable and as pious as the growers and consumers. A number of authentic narratives assure us that itinerant preachers, in more sects than one, carry on the double avocation of converting souls and buying up the souls and bodies of men, women, and children for sale. An instance, in the fine old Methodist preacher who dealt in slaves, may be found in World Slavery as It Is, page 180. In the higher circles of society at the South, this would be thought low and vulgar, equally so with buying up horses and swine. But slave trading on a sufficiently large scale is considered a reputable employment, just as the large importers and distillers of rum are respected among us, while the dealer of drams is despised. The items that follow are from the work of Mr. Weld, just mentioned, and which, for 13 years past, has had an extensive circulation and eager perusal in our widely extended country, without having had one of its vast collection of facts disproved or even questioned to our knowledge. That they, the smaller dealers, are not despised because it is their business to trade in human beings and bring them to market, is plain from the fact that when some gentleman of property and standing, and of a good family, embarks in a Negro speculation, and employs a dozen soul drivers to traverse the upper country and drive to the south, coffles of slaves, expending hundreds of thousands in his wholesale purchases, he does not lose caste. It is known in Alabama that Mr. Irwin, son-in-law of Henry Clay and brother of J.P. Irwin, formerly postmaster and late mayor of the city of Nashville, laid the foundation of a princely fortune in the slave trade carried on from the northern slave states to the planting South. That Honorable H. Hitchcock, brother-in-law of Mr. E., and since one of the judges of the Supreme Court of Alabama, was interested with him in the traffic, and that a late member of the Kentucky Senate, Colonel Wall, not only carried on the same business a few years ago, but accompanied his droves in person down the Mississippi, not as the driver, for that would be a vulgar drudgery, beneath a gentleman, but as a nabob in state, ordering his understrappers. It is also well known that President Jackson was a soul driver, and that even so late as the year before the last war, he bought up a coffle of slaves and drove them down to Louisiana for sale. Thomas N. Gaston, Esquire, the principal slave auctioneer in Charleston, South Carolina, is of one of the first families, and moves in the very highest class of society there. He is a descendant of the distinguished General Gadsden, of Revolutionary memory, and member of the Continental Congress, afterwards governor of the state. The Reverend Dr. Gadsden, rector of St. Philip's Church, Charleston, and Reverend Philip Gadsden, and Colonel James Gadsden of the United States Army are his brothers. Under his hammer, men, women, and children go off by thousands. Its stroke probably sunders, daily, husbands and wives, parents and children, brothers and sisters, perhaps to see each other's faces no more. Now, who supplied the auction table of this Thomas Gadsden, Esquire, with its loads of human merchandise? These same detested soul drivers, forsooth, as they are sometimes called, even at the South. They prowl through the country, buy, catch, and fetter them, and drive their chained coffles to his stand, where Thomas Gadsden, Esquire, knocks them off to the highest bidder, to ex-Governor Butler, perhaps, or to ex-Governor Hayne, or to Honorable Robert Barnell Rhett, M.C., or, it may be, to his own Reverend brother, Dr. Gadsden. World Slavery as It Is, page 174. One illustration more must suffice. During the great Negro speculation of 1836, when all the Negro-consuming states were insanely eager to purchase at high prices, and all the Negro breeding states were enriching themselves with the sales, the soul drivers, now multiplied beyond all former precedent, were separating wives and husbands, parents and children, with unwonted celerity, and driving them in chained coffles, or droves, as speedily as possible to the market. The whole South was feverish and in motion. Money for the operation was in brisk demand. The banks extended their loans and were drained. Capitalists demanded high rates of interest. Through the banks they made loans to the speculators. Then it was that the trustees of the General Assembly of the Presbyterian Church, lured by these high rates of interest, though well knowing, as everybody did, the purpose for which their capital was wanted, withdrew their funds to the amount of $94,692.88 from the Northern institution where they were drawing the usual interest, and invested them in the Southwestern banks, where they would be loaned to the speculators in the bodies and souls of men, women, and children. In the reaction and general bankruptcy that followed, the Presbyterian Church lost $68,893.88 of their funds. Had the General Assembly and its trustees understood and felt, as they should have done, the sinfulness of the legal relation of master and slave, they would have understood and felt the sinfulness of this abominable slave trade, which the relation involves, and the consequent sinfulness of loaning money to carry it on. But they deemed it ultra and fanatical to recognize these self-evident truths, and therefore they lost the greater part of their funds. We dismiss this feature of the slave code, presuming that its paternity, its character, its vitality, and its practical workings have now been made sufficiently clear. In this feature of the system, its slave traffic, the people have been found no better than their laws, and the church no better than the people. If you would like to purchase the American Slave Code, you may do so by visiting the description area under this video. Click the link to the book patch. There you will be routed to this book. I thank viewers in advance for the purchase of the American Slave Code, as your purchases greatly support this channel and the intense work involved in the republishing of history by first-hand eyewitness account.